Good morning and welcome to Legal Aspects of COVID-19 Vaccination for Employers, an IRC network event hosted by the Northeastern Pennsylvania Industrial Resource Center. Today's presentation will include a discussion with attorneys James Devine and Caitlin Donahue of the firm of Cipriani and Werner, a firm with over 150 professionals operating in 15 offices throughout the Mid-Atlantic states. My name is Eric Joseph Soda, and I'm the President and CEO of the Northeastern Pennsylvania Industrial Resource Center. And our moderator for today's question and answer sessions will be NEPIRC's marketing specialist, Chelsea Coslett. We are thankful to the firm of Cipriani and Werner for partnering with us for today's important event and sharing with us the goal of accelerating manufacturers' recovery and rebound from the COVID-19 pandemic. We look forward to restarting Pennsylvania's economy through a strong manufacturing sector. Today's event is a collaboration of the Industrial Resource Center Network, which consists of the 7 industrial resource centers located strategically throughout the Commonwealth of Pennsylvania to serve our nearly 15,000 small and mid-sized manufacturers and their 550,000 employees. Working collaboratively, the Industrial Resource Centers provide small and mid-sized manufacturers with the assessments, technical services, training programs, and technical expertise that they need in order to compete and win in today's global manufacturing economy. While each IRC customizes its services to the unique needs for its region, at a general level, our services fall into the categories of continuous improvement, quality management systems such as ISO 9001, leadership development, and talent pipeline development, strategic services, growth services, and more recently, Industry 4.0 technology implementations and cybersecurity. This event is made possible through the support of our respective IRC staffs, boards of directors, and partnered stakeholders, including the Pennsylvania Department of Community and Economic Development, the National Institute of Standards and Technology Manufacturing Extension Partnership Program, and the Appalachian Regional Commission. Our technology partner, Posture Interactive, along with our own IT specialist, Randy Yash, are working behind the scenes to ensure a high-quality event that provides value for over 400 participants. Several of our stakeholders are participating in today's event, along with several elected officials who share our passion for the manufacturing sector, including the Office of Governor Tom Wolf, the Office of Congressman Matt Cartwright, offices of Senator Bob Casey, as well as state senators Lisa Baker, John Blake, and several others. Before we begin, I'd like to take care of a few housekeeping ideas. First, as you've seen, all attendees are automatically muted and your camera is turned to the off position. Attendees can submit questions at any time using the question and answer button that appears on your screen, and I ask you to take a moment to locate that button now. Just please note that if you are watching a rebroadcast of this event, your question and answer button will not be active during that time. Our presenters will field questions at designated breaks throughout the presentation with the help of our moderator. Given that there are over 400 participants in today's event, it is likely that we will not be able to answer all of your questions. But rest assured that we will provide a document that summarizes every question and every answer on our website. You will receive a link to that by the email through which you registered for this program. This document will not only summarize every question and answer, but will also include a link to the pre-recorded version of this webinar so that you can watch it again and again or pass it along to your colleagues. Once again, you'll receive that link through your email. Please note, however, that if you do watch a rebroadcast of this event, it was recorded on today's date, February 10th, 2021, and the legal environment regarding COVID-19 vaccinations may have changed since then. If you have any concerns about those changes, we encourage you to contact our presenters at the email that they will provide toward the end of their presentation. You can also check with your own legal counsel if it is different from Cipriani and Werner, or you can contact your IRC representative using an email that I'll share with you toward the end of the presentation as well. I thank all of our participants, stakeholders, and others for their time today, and I'm glad to introduce attorneys James Devine and attorneys Caitlin Donahue from the firm of Cipriani and Werner. We appreciate their sharing in the mission with us of revitalizing our manufacturing community. We're very fortunate to have them and their over 30 years of experience in this particular aspect of law. Thank you, Jim and Caitlin. We look forward to you sharing your knowledge with us today.
Good morning. Today we're going to review the legal aspects of COVID-19 vaccination for employers. I am your presenter, Jim Devine. I'm joined today by my colleague, Caitlin Donahue. Before we begin, I want to thank NEPIRC, Eric and Chelsea in particular, as well as the rest of their team for their vision and their hard work to bring this presentation to life. I also want to thank all of our audience, all of the employers that are participating today. As Eric mentioned, we have over 400 employers participating. Your involvement in today's presentation is a testament to your commitment to reopening our economy and to the protection and safekeeping of your employees as we endeavor through the COVID-19 pandemic. What we hope to achieve today is to provide some background information about the current state of the law and the culture surrounding employer-mandated vaccines for the COVID-19 pandemic. It's important to note, as referenced in Eric's preview, that this information is evolving on almost a daily basis. We intend to provide an updated presentation in a few weeks, but for today, we're going to outline the different types of mandates or vaccinations that are available for employers. We're going to help you navigate and identify the laws that pertain to those vaccinations. We're going to talk about what to do to implement the vaccination process, develop a plan, and work through some of the issues presented by your specific employment base so that you can successfully ensure the safety and well-being of your employees. We have a lot of information to cover in a short period of time, so I encourage you all to grab a paper and pen, take notes, and jot down your questions. Each of our presentations is designed to deliver information to our employer partners, but also to solicit your questions so that we can help you specifically address issues germane to your workforce. As Eric mentioned, there are several ways to harvest the question from today's audience. If possible, throughout the course of today's presentation, we would like you to upload general questions, and we will endeavor to answer those as we proceed through our presentation. In the days that follow, NEPIRC has developed a platform to harvest additional questions that Caitlin and I will then address in a fact sheet format to provide to all audience members. If you have specific questions or concerns or want to work with us on a particular policy or mandate, you may contact us at the email address contained at the end of the presentation. In any event, we will do our very level best to answer all of your questions and keep you informed as to the legal aspects of COVID-19 vaccinations for employers. In December of 2020, the EEOC provided guidance as to vaccinations for employers for COVID-19. Specifically, the EEOC indicated that employers can implement and enforce mandatory COVID vaccination policies for employees. Who is the EEOC? The EEOC is the Equal Employment Opportunity Commission. This is a federal government agency dedicated to the guidance and interpretation and enforcement of all federal discrimination laws. They provide guidance for consideration of policy, protocol, and exceptions that assist both counsel and employers in navigating the myriad of employment issues related to employment discrimination, and in this case, vaccination for COVID-19. Again, we're going to explain the specifics of their guidance. We're going to help you determine what type of mandate is best for your vaccination for your employees, whether that be mandatory or voluntary or partial mandatory vaccination. We will describe the options for who will administer the vaccination, who will receive it, and what to do if someone refuses it. There are so many questions swirling about this issue. Just since the inception of the concept of our presentation, there has been almost daily development as to the law, guidance, and culture surrounding employer-mandated vaccines. Questions still abound, including, will businesses have the option for providing on-site vaccinations? Will they incur any potential liability for providing required vaccinations? Should businesses become involved in public awareness or educational campaigns for their employees? Will vaccinated individuals be exempt from future quarantine requirements? And what are some of the other ancillary issues like transportation, storage, or accessibility? Before we go any further, Chelsea, I believe we had a question come up already.
Yes, we did, Jim. Caitlin, I'm going to direct this question to you. What if you live in one state but work in another? How do the state-to-state vaccination rollout measures work then?
Thank you, Chelsea. That's actually a great question. Right now, each state has been handling this a bit differently. For instance, in Pennsylvania, residents are permitted to receive the vaccine outside of the state. Non-residents and priority groups are also able to receive the vaccine in Pennsylvania as well. In New Jersey, however, anyone who lives in New Jersey or works in New Jersey can receive the vaccine. The same goes with New York and Connecticut. Delaware, however, only provides the vaccine to residents of Delaware only. Best practice, if you're eligible for the vaccine in 2 different states based on your residence and based on where you work, you should receive the vaccine in whatever phase allows you to get it the quickest.
Thanks, Caitlin. We also have another question that came in as well. I'm going to direct this one to Jim. Jim, do employers have to offer PTO for mandated vaccination?
You know, Chelsea, I went to school for over 20 years to provide this specific answer. It depends. There are a variety of factors that the employer needs to consider when determining what, if any, compensation might be payable for an employee to receive a vaccine. Under the Fair Labor Standards Act, time spent waiting for or receiving medical attention on the premises or at the direction of the employer during the employee's regular work hours on the days that employee is normally working is compensable time. So as we move through today's presentation and employers are considering whether or not they want to mandate a vaccine on site, whether they contract with an outside third party to administer vaccines for their employees either during work hours or outside of work hours, or they make the vaccination policy completely voluntary, there are compensation issues that will be presented. If it's during work time, on work hours, either at the direction of the employer or on the employer's premises, employees will be compensated through their regular payroll system under the provisions of the Fair Labor Standards Act. Other companies, such as Dollar General or Trader Joe, have initiated incentive programs. Dollar General, I believe, is offering up to 4 hours of compensation for employees to undertake the vaccine. Trader Joe's incentivized program provides for 2 hours of compensation to receive the vaccine. The theory that these employers have employed is that if the employees are incentivized or compensated to receive the vaccine outside of work, they don't need to miss time at work to get the vaccine, be safe, be healthy. Since we started our analysis for this presentation, the Society for Human Resource Management, SHRM, through their legal counsel, has initiated a letter to the EOC seeking further guidance and further clarification on these compensation issues. Specifically, they seek to determine if and when PTO is appropriate and or whether the incentivized programs are actually legally viable. So stay tuned. We'll have more information as the EEOC provides updated guidance.
Thanks, Jim. And those are all the questions that we will take at this time. Jim, I will turn it over to you to continue.
Thank you, Chelsea. Many recent surveys have indicated as much as 60% of Americans are ready or willing to receive the vaccine. That's fantastic news. That's a tremendous buy-in from American employees. However, those statistics also belie the fact that 40% are unsure or are unwilling. The politics surrounding the vaccination approval and distribution process has created some skepticism about the vaccine safety. Employers implementing a mandatory policy should endeavor to provide an educational campaign. This campaign should recognize the current unknowns about the COVID-19 vaccine, including its effectiveness in reducing transmission of the disease and potential long-term side effects. It should prepare employees for the vaccine requirement. Employers should prepare themselves for employee resistance and consider the potential effects of mandatory vaccination policy on employee morale, which may be both positive or negative depending upon the employee foundation and its composition of its workforce. Remember, these are all hardworking adults. They need to be respected. Their concerns need to be addressed. You have to have a good reason to give people about why it is ethically right for them to subject themselves to the vaccine, or potentially they won't want to get it. So is the vaccine right? Is it ethical? Some employees may have social, cultural, religious, or political reasons for not wanting to get the vaccine. The employers need to contemplate whether or not they want to distinguish between people who want to get the vaccine or have a good reason who don't. Another factor to consider is the effectiveness of the current vaccines that are authorized. They are purportedly 94% effective in reducing the risk of developing COVID-19, but there still are many questions about side effects and their potential for reducing the severity of the illness if it is contracted. What we are recommending here today is that employers consider drafting a policy. As we discussed earlier, the information is evolving. This is the time to begin to take a proactive approach to prepare for the day that vaccine distribution is harmonized with employers' efforts. We want to draft a policy to note the requirements of the vaccine to meet the needs of your particular business and employment base. We want to explain why it is required, and we want to offer employees avenues and a forum to address their concerns. It's important to highlight that some customers and vendors may express a business need or requirement for mandatory vaccination. In short, they may require your employees to be vaccinated in order for them to enter their workplace and further your business. It is also important to mention that at the start of the COVID pandemic, we saw a rise in claims for negligence related to employers that did not follow CDC guidelines for providing a healthy and safe work environment. As the CDC now includes vaccination in its list of potential requirements for producing a healthy and safe work environment, the need to be cognizant of potential legal liability for failing to provide that vaccine is an imperative. Effective communication and dialogue remains critical. How do you communicate with your employees about the vaccine? Are you able to show that the vaccine is the only thing to prevent them from transmitting the disease? Of course not. You need to remain vigilant in your approach to a healthy and safe work atmosphere. With or without the vaccine, the CDC guidelines and the state regulations related to the reduction of COVID transmission remain in effect. PPP must still be provided. Employers need to educate their employees as to the facts surrounding the vaccine, the risk associated with forgoing the vaccine, and options for vaccination. The FDA controls the distribution and authorization of vaccines. The 2 vaccines that are in play at this time were authorized under the Emergency Use Authorization, or EUA. This is a mechanism to facilitate the availability and use of medical countermeasures, including vaccines, during public health emergencies such as the current COVID-19 pandemic. The FDA must determine and distinguish between the known and potential benefits of the vaccine and the known and potential risks of the vaccine before providing any authorization. They put the vaccine through rigorous tests spanning 3 phases of development and review. Part of the FDA's evaluation of the EUA request COVID vaccine includes evaluation of the chemistry, manufacturing, and controls for the vaccine. The FDA is staffed by career scientists and physicians who globally recognize in their expertise and the complexity of development of vaccines. So getting to the question at hand, can we mandate a vaccine? The short answer from the EOC is yes. Employers can require employees to receive the COVID-19 vaccine as a condition of returning to or remaining in the workplace. But before we run out and develop a mandatory policy for vaccination, there's a few points of consideration. First of all, the EEOC guidance highlights 2 exceptions to the rule. Employees that have legitimate medical disabilities under the ADA who may not be able to take the vaccine or have the vaccine administered, and sincerely held religious beliefs. Employees who have religious beliefs that prevent them from undertaking the vaccination process. Another point of consideration is the fact that currently the vaccines are not wholesale available to all employees in every jurisdiction and every state. For example, in Pennsylvania, the vaccines are only qualified for employees over the age of 65 and or folks between 16 and 64 that have specific medical conditions that mandate the vaccine at this time. So to proceed now in developing an instantaneous mandate for vaccines is premature. They're not available for all employees. Let's return to the exceptions. We talked about medical disability and religious beliefs. If an employer determines that an unvaccinated employee presents a direct threat to the health and safety of persons in the workplace, and they cannot be reduced or eliminated through reasonable accommodation, the employer can exclude the employee from the workplace. Focus on exclude, not terminate. We still have some work to do before we separate the employment relationship. We'll talk about the criteria for direct threat in a few moments. One fundamental rule I'd like you to walk away from this presentation with is the notion that no termination of employment should occur as it relates to an employee's refusal to undergo a vaccine, mandatory or voluntary, without consulting qualified legal counsel. As you will find throughout the course of our presentation today, there are a number of laws and exceptions that apply to the vaccination process. Your managers and supervisors need to be trained. Management needs to understand and have effective legal counsel to walk through a case-by-case analysis of each refusal. At the time of issuing the December 2020 guidance, the EEOC found that COVID-19 meets the direct threat standard. That means that the guidance is going to be softened and employers are going to enjoy a greater latitude in enforcing their policies. But the EEOC has been quick to point out the exceptions and require employers to follow the mandates set by the ADA and Title VII in addressing these exceptions. What are the medical disabilities at issue? They're too numerous to count. The ADA has list upon list of medical conditions that are considered a disability under the statute. People with weakened immune systems, people with autoimmune conditions, folks that suffer from Bell's palsy, pregnant women or women who are breastfeeding are all at risk for the COVID vaccine. In addition, as we've experienced throughout the COVID-19 pandemic, there are employees that suffer from other less identifiable conditions that still may present an exception to undertaking a mandatory vaccine. Conditions that might include severe anxiety or depression disorder or a particular phobia. While the ADA specifically does not require employers to provide accommodation for a general fear, they do require acknowledgement, address through interactive process of diagnosed conditions such that a diagnosed condition of anxiety or depression or phobia will give rise to the process of interactive accommodation for accepted employees. What does the ADA entail? Well, first, the employee needs to present with a disability. As I stated earlier, there are list upon list of disabilities outlined under the ADA. It's an inexhaustive list, but the employee has to present a documented and diagnosed disability for accommodation. Once the disability is presented, the employee needs to work with the employer through the interactive process. This is dialogue and communication between the employee and employer to derive a determination as to whether there is a reasonable accommodation that can be employed to facilitate the vaccination in the face of the documented disability. Employers are encouraged to consider as part of their plan a form for documenting the request for accommodation, but it is imperative, and I will repeat this throughout today's presentation, it is imperative to provide training to your supervisors and management that the form does not start the process. An employee's report is an oral trigger of the need to participate under the ADA in the interactive process. Employers that fail to work with their employees to attempt to maintain the employment relationship do so at their own peril. Remember my initial rule, do not terminate an employee despite the circumstances without the benefit of review with counsel in the context of refusal to undergo a COVID-19 vaccination. Sincerely held religious beliefs, what does that mean? Well, most courts are very lenient in their approach to what is a sincerely held religious belief. Does the employee need to hold a religious belief that conflicts with employment requirements? Has the employee informed his or her supervisor of the conflict? Has the employee been penalized or undergone an adverse employment action in regard to their sincerely held religious beliefs? As I mentioned just a few moments ago, the takeaway from this slide is training. Oral requests may trigger the interactive process. Managers and supervisors must be trained to recognize and appropriately respond to accommodation requests and to direct employees to complete any appropriate form and or otherwise document their diagnosis, their request for accommodation, and their reason for the request. A form can be required, but it cannot dictate the interactive process. When presented with a religious belief request or exemption, there are certain factors to consider. Whether the employee behaves in a manner inconsistent with the professed belief, whether the belief is likely being sought for secular reasons, or could the employer have accommodated the religious belief without imposing an undue hardship? Employees do not need to be part of an organized religion to advance a religious belief exemption. We cannot, as employers, cannot require a letter from clergy or their priest, but we can ask them to explain their religious beliefs. If the employer cannot accommodate an employee who refuses the vaccine due to sincerely held religious beliefs, they may exclude them from the workplace under the prescribed policy. But they must participate first in the interactive process to determine whether there are any internal internal accommodations, and then proceed to external accommodations. External accommodations can include remote work or a leave of absence, both of which we will discuss as we proceed through our process here today. I've talked a lot about the direct threat defense under the ADA. The guidance offered by the EOC suggests that even where an employee has an exception, whether it be a medical disability or a sincerely held religious belief, if the employer cannot accommodate that exception to the point that it can ensure the health and safety of the remainder of the workforce, they can determine that the employee represents a direct threat. There are criteria for accommodation, and I want you to focus closely on this slide. The duration of risk presented by the unvaccinated employee, the nature and severity of the potential harm presented by the unvaccinated employee, the likelihood that harm will occur, how imminent that harm is to others in the workplace. These are the 4 criteria. The question I would posture is, how do we prove the duration, the imminent harm or the likelihood of harm? How do we demonstrate that an employee is a direct threat to the workforce after we have worked with social distancing en masse over the course of the last year when now confronted with the vaccination issue? There are no set answers. I have investigated this claim or this defense in preparation for this presentation, and there are few specific examples to align with this criteria. This centers back on my recommendation that when presented with this situation, when you confront an employee who refuses a vaccine based upon an exemption and no accommodation is readily available, that you include competent legal counsel so that you can navigate this difficult decision and minimize your exposure for lawsuit under either Title VII or the ADA. It is imperative that employers conduct an individualized assessment of these 4 factors on a case-by-case basis. This law and the guidance surrounding this particular element of the guidance is likely to evolve as public health officials learn more about the disease, the vaccines, and immunity to COVID-19. The guidance may also change as the population begins to develop herd immunity. After that, an unvaccinated employee may no longer pose as much of a direct threat as initially thought. So is that it? No. That does not mean that an employer may terminate the employee's employment. Again, we need to consider and assess all accommodations, both internal and external. This implicates policies, past practices, and job descriptions. There's a fundamental rule in employment law. It's not codified or written down. It's learned over the course of a practice. And that is that, number 1, the employer is expected to maintain the employment relationship with the employee at all times. I don't care which court you're in, from unemployment to workers' compensation, state or federal, discrimination or otherwise. A court is going to look at the employer's documentation and their effort to retain the employee in gainful employment. When we speak of documentation, the unwritten rule is that employers need to have a rule, document their rule, that's write it down, publish that rule in a manner accessible to their employees, make sure their employee has access to the rule, understands the rule, and most importantly, understands the consequence of violating the rule, and then document infractions in your progressive discipline as you attempt to preserve the employment relationship process and train your employee to better identify and comport with the rule. If those elements are missing, in any case, including cases that may arise as we address refusal to undergo vaccination in the face of our mandated policies, the employer will be at a disadvantage in prevailing in any courtroom. Even after the vaccination, employers are going to be required to continue to impart the CDC guidelines for providing a healthy and safe work environment. Under OSHA, there is a general duties clause that requires all employers to provide a safe work environment to prevent the spread of COVID-19. Federal administrative agencies like the CDC have provided guidance for employers regarding COVID-19. OSHA guidance suggests that an employee who refuses vaccination because of a reasonable belief that they have a medical condition creating a real danger of serious illness or death may be entitled to whistleblower protection under the OSHA Act. This is significant. Let me read that again. OSHA guidance suggests that an employee refuses vaccination because of a reasonable belief that they have a medical condition creating a real danger of serious illness or death may be entitled to whistleblower protection under the Act. The reason that I am identifying and singling out this guidance from OSHA is it appears to heighten or complicate the standards that we've reviewed from the guidance offered by the EEOC and the two exceptions that they provide for consideration in the interactive process. This is an example of the competing legal statutes that require the assistance of learned counsel to help walk employers through this difficult issue. Remember that until December of 2020, the CDC recommended a series of guidelines for implementing a safe working environment. This included wearing a mask, social distancing, it included quarantine measures, as well as appropriate cleaning measures. Vaccinations have been added to the CDC guidance, but the pathway for employers still remains unclear. Another component of the guidance under the EEOC is the determination of whether or not your vaccination process and policy constitutes a medical exam under the ADA. Administration of COVID-19 vaccines by an employer or a third party which the employer has contracted to provide a vaccination, such as an outside health clinic or similar provider, is not a medical exam. That's the language of the guidance. But let's delve a little deeper into this issue and understand some of the complexities of that guidance. Although the ADA prohibits disability-related inquiry during certain phases of the employment relationship, the EOC's vaccination guidance confirms that requiring an employee to take a vaccination is not a medical exam because it does not seek information about an employee's impairment or current health status. This is significant. It's significant because the CDC suggests in its guidance that employers and/or healthcare providers that are administering vaccines secure pre-vaccination screening questions to ensure the health and safety and appropriateness of the vaccine for the employee receiving the vaccine. The imperative here is that the minute that an employer begins the pre-screening question process, the vaccination moves into the category potentially of a medical examination, and those questions then need to be centered on a legitimate business necessity. We tie back in some of the other concepts that we've learned so far in our presentation. The EOC says COVID-19 qualifies as a direct threat. There's going to be some leniency under the ADA. We understand that while there's leniency, We have to take great precaution before we separate or terminate an employee that refuses that vaccine. In developing our policy, whether it's voluntary, partially mandatory, or mandatory, we need to determine who and how that vaccine is going to be administered. How it is administered and by whom is going to dictate, in many instances, whether it is a medical exam and whether that imposes greater requirements on the employer to scrutinize the pre-screening questions. Another example of how the development of the policy, the development of the program, the education and training of your managers and supervisors should be undertaken under the guidance of qualified legal counsel. If things weren't complicated enough, let's meet GINA. GINA is the Genetic Information Non-Discrimination Act. GINA prohibits discrimination on the basis of genetic information. Although the EEOC guidance makes clear that vaccination alone does not violate GINA, the sorts of questions employers may ask in support of the vaccination program might cause problems under GINA. To avoid running afoul, employers should strongly consider outsourcing any questions regarding family history or genetic indicators to a third-party medical provider. Do you see how things are becoming more complicated as we move through this process? Ask a question, don't ask a question. It is a medical exam, it is not a medical exam. These can be easily navigated with help and guidance and consideration of these competing policies on a case-by-case analysis of each employer, the scope and breadth of their business, and the size and demographic of their employee base. I reference GINA as it is listed in the EEOC guidance and stands as yet another federal statute that needs to be considered when developing our vaccination policy. There is language that employers can include in their forms, in their questionnaires, that provide a safe harbor and will provide an affirmative defense from any claim for breach of GINA's provisions in acquiring the necessary pre-screening vaccination questions. So, do our questions have to be job related? Yes or no? While the administrator of the vaccine is not a medical examination under the ADA, the CDC suggests that healthcare providers should ask certain pre-vaccination screening questions to protect the health of the person receiving the vaccine. Again, these questions may constitute a medical examination. Pre-vaccination screening questions may elicit information about employers' disability. This includes questions regarding medical conditions, preventing the person from receiving the vaccination, or indicating that an individual should receive the vaccine from their personal physician or hospital. So you might ask, Jim, how do I do this the easy way? How do I avoid the pitfalls of the pre-screening? One way is to have a voluntary policy for vaccination. If employees are seeking the vaccination on their own with their own healthcare provider at their local pharmacy, with or without an incentivized program, an employer can avoid many of the pitfalls surrounding the pre-screening process. As we move into a mandatory or designated vaccine policy, whether it's for a specific category of employee or all employees, employers need to consider whether or not they're going to administer the vaccine or contract a third-party provider to administer the vaccine. That will be the trigger for the evolution of the vaccine to a medical examination and require the job-related considerations for those questions. So what can an employer do? And if an employer is going to require that employees answer pre-vaccination questions, you have to establish that those questions are job-related, consistent with your business necessity, and based on objective evidence. You can then determine whether the employee presents a direct threat to their safety or the safety of others in the workplace. As a matter of law, to comply with the ADA, employers may only ask employees these questions if doing so is job-related and consistent with business necessity. I would submit to you today that this is an area of the guidance of the evolution of this law that is going to continue to develop. The EEOC guidance needs to balance its statement that COVID-19 in and of itself as a pandemic is a direct threat with these other considerations. Many of the employers, large manufacturers who are in our audience today, have remained open and active in some measure throughout the pandemic process, throughout the course of 2020. How can we possibly establish today that there is not a different job necessity or evaluation that has not persisted throughout the course of 2020 and the COVID pandemic process? The EEOC's COVID guidance differs regarding employees receiving a vaccine from third party that do not have a contract with an employer, such as their local pharmacy or healthcare provider. Under those circumstances, as suggested, the business necessity requirement does not apply for screening questions because the employer is not harvesting the personal, medical, and health history information. Pre-vaccination questions could implicate GINA if they elicit disability-related information. Employers must evaluate their questionnaire with counsel to ensure that potential genetic conditions in the screening checklist for vaccine contradictions do not exist. Simply asking or even requiring an employee to show proof of the received COVID-19 vaccine is not prohibited. So again, if we employ a voluntary policy that provides for an employee to simply secure the vaccine on their own by a particular date and to show proof of acquiring that vaccination, the employer will not run afoul of the ADA or GINA in the pre-screening process. Again, that is because an independent medical provider is providing the vaccine. In this way, you can implement a mandatory or partially mandatory process requiring a vaccine by a certain date, but the administration of the vaccine is voluntary and the employee's responsibility. Be careful not to ask why they did not receive the vaccine when acquiring proof of the vaccination. Employers who ask employees to provide proof of the vaccination should exercise caution and ensure the information does not disclose any medical information. Most outlets that are providing distribution of the vaccine at this point provide a vaccination card or a printout from the vaccine administrator stating that the COVID-19 vaccine has been received, the date and location, and the employee's name. That is all that is required. Any additional information may run afoul of those pre-screening questions. Employers may prefer that employees get the vaccine independently for these reasons. The employer should direct the employee not to provide any medical or genetic information when providing proof of the vaccination. If we're developing a documented plan and form, we should also include a specific directive that the employee is only to provide proof that the vaccination occurred, the place, date, or dates, and the name of the employee. That is all the information the employer should require for proof of the vaccination. What about HIPAA? The U.S. Department of Health and Human Services issues a standard for privacy of individually identified health information. This is called the privacy rule under HIPAA. Generally, HIPAA does not apply to employer actions. HIPAA applies to healthcare providers, healthcare clearinghouses. It only applies to employers in certain circumstances where they have self-insured health plans and administer or clear their own invoices for payment with a healthcare provider. Employers may ask for proof of vaccination, again, without violation of HIPAA. They need to develop a plan for the safe retention of any protected health information they receive through the vaccination process, and should again evaluate their protocols for that safekeeping with accomplished counsel. When we receive the information, retention of the vaccination shall be kept in separate folders apart from any personnel file. This will ensure that the employee's protected health information is kept confidential. Consider implementing non-mandated or mandated vaccination policies that do not implement the pre-screening process. This will reduce the intake of protected health information. We talked earlier over the course of a couple of slides about the religious exemption to the under the EOC guidance for vaccination policy. If an employee holds a sincerely held religious belief, it may provide an exemption under Title VII to undergoing the vaccination process. I've included this slide here as a marker in our presentation today because when legal investigation as to the application of vaccines, the relative laws that would apply to the vaccination process commenced in late November and December, we looked back to what standards were applied to the distribution and vaccination of the influenza vaccine. It's important to note for today's presentation that the guidance provided and the law that developed under the influenza vaccination process did not highlight the religious exemption the way the EOC guidance has forwarded here. That is not to say that religious exemption has not existed. It is a protected class under Title VII and has been a part of our employment culture and environment since the inception of Title VII. The point that I raise here is that employers need to be prepared and again need to focus on the training of their employees, management and supervisors as to the two exceptions, medical disability under the ADA and the religious exemption. Many employers, many managers, many human resource offices are adept at dealing with the ADA and accommodation for medical disabilities. The vaccination policy and protocol will be a new overlay to that well-established policy. However, religious accommodation is seldom witnessed and not regularly dealt with. Employers need to remember that there are two exceptions. The religion exemption is emphasized for the COVID-19 vaccine. They need to train their supervisors and management in the interactive process. They need to identify reasonable accommodation. That process can start now, both the training and the evaluation of your workforce as to how you will handle the reasonable accommodation. If you insist on a mandatory policy that involves pre-screening questions, we need to consider how we are going to justify those questions as business or job related. You need to navigate the application of the direct threat. What do we do with an employee? How do we identify and determine that an employee remains a direct threat based on one of these exceptions, even in the face of potential accommodation? And remember those 4 criteria that we reviewed earlier, and rely on past and present practices in your protocol for established precedent of how you have accommodated disabilities and exceptions in the past. We haven't talked a lot about workers' compensation. In Pennsylvania, workers' compensation is the exclusive remedy to most occupational injuries and illnesses that occur in the workplace. If an employee sustains an occupational injury or acquires an occupationally induced disease, or illness in the course and scope of their employment, causally related to their employment, the employer's liability is limited to wage loss benefits for the period, any period of disability, as well as reasonable and necessary medical expenses causally related to that injury or illness. We need to examine how that concept will apply to vaccination and your policy. Employers may be liable for any side effect that results from the vaccination process. Moreover, employers should be prepared, if retaining an outside third party to contractually administer the COVID-19 vaccination for their employees, indemnification clauses and expectations for working through liability issues with that third-party contractor. Ask yourself what happens if the employer, or if the third-party contract administers a bad dose of the vaccine because it was not properly stored or not properly administered. What happens if the injury or side effect is due to a dirty syringe or a broken needle? Employers who are contracting with a third-party vendor should make sure that the contractual language includes appropriate indemnification clauses so that the employer, notwithstanding the exclusive remedies under the Workers' Compensation Act, can enjoy greater protection for the bad acts of the third-party vendor. Make sure you review your liability and workers' compensation insurance to make sure that your policies will cover the vaccination effort, and make sure that any third-party vendor that is contracted is also properly insured. One other element that we referenced earlier, but we have not discussed in any detail, is women who are pregnant or breastfeeding. Employers may want to grant exceptions to pregnant or breastfeeding women who do not want the vaccine. As of January 7th, 2021, the EUA that I referenced, the approved vaccines, had not been tested on pregnant or breastfeeding women. The CDC advises that pregnant women may choose to get vaccinated, but suggests that they may pursue vaccination through their healthcare provider so as to address any concerns or alternative issues related to their pregnancy and corresponding medical or health condition. Some states are not administering vaccines to pregnant or breastfeeding women, recommending instead, again, that they seek a vaccine if desired through their healthcare professional. I believe I gave the example earlier. This is a non-issue at this point, potentially in Pennsylvania, based on the limits and the categories of the population that are provided access to the vaccine at this time. However, when the vaccine becomes more widely available, as we seek to implement our policy, we will need a manner to address pregnancy and breastfeeding within that policy as a potential exception. An employer who allows a non-vaccinated employee to come to work is at risk for liability or exposure of the spread of COVID-19. In my experience, our office is still working on a flex schedule. We occupy 4 floors and over 10,000 square feet. We have our employees come to work on a graduated daily schedule, reducing our interaction in the office. We have the office cleaned 3 times a week with a specific fogging mechanism that is supposed to disinfect for the pandemic. And we are vigilant in requiring each other to wear masks while we are working together, particularly in public places. Notwithstanding those efforts, we still have employees who refuse to come to work or come to work when they have to work in any proximity to employees. We have employees that have already announced their refusal to undertake the vaccine, whether it be because of a particular medical condition, religious belief, or the fact that they just believe the vaccine is unsafe or unseemly in some manner. We've talked about the need for the employer to address these refusals, to evaluate potential accommodations, and to take whatever steps that are appropriate, necessary, and available. We don't have to create them, but we have to take available steps to preserve the employment relationship. This requires us to look back at our job descriptions and other alternatives such as remote work. Job descriptions, and this is another point if you haven't been taking any notes to this point, write this down. Job descriptions are the cornerstone of an effective employment practice. Job descriptions are the cornerstone of an effective employment practice. I do a lot of public speaking about a variety of employment issues. Every one of them overlaps with job descriptions. It's important to have policies. It's important to have handbooks. I suggest that you document your guidelines for your employment culture and its overlay to applicable employment laws as completely as possible. But if you do nothing else through this process, evaluate your job descriptions, ensure that they are accurate and up to date, as they are the cornerstone of your effective employment practice and your address of accommodation and any corresponding defense that we will entertain if we in fact need to refuse ongoing employment, particularly in view of an exception such as medical disability or religious belief. Chelsea, do we have any questions?
Thank you, Jim. Yes, we do. Caitlin, how do employers go about implementing new job descriptions?
That's a great question, Chelsea. So what employers should do is make this an open route of communication between the employers and the employees themselves. Take a step back and meet with your employees currently within your business practice. Meet with your employees, take a look at the job descriptions that you have currently, and assess with those specific employees, what do they believe are the essential functions of their job? What do they believe can they do remotely or can they not do remotely? After getting some feedback from your employees, you should then take this back and discuss with senior management or supervisors and see how we can accommodate the workforce to make a better, clear and concise job description. And once that job description is finalized, you should administer a job description acknowledgement form, having each employee then sign, read, review their new policies that they now have to work under.
Thanks, Caitlin. Jim, I'm going to hand it back to you in the essence of time so that we can ensure that we get through the entire presentation.
Sure. The next slide that we're going to review is what's in a job description. Picking up on Caitlin's answer to the last question, it's imperative that employers make sure they update their job descriptions. I want to focus most importantly on the delineation between essential and marginal functions. An essential function is a function that exists for the job. The performance of that function is essential to the job. Eliminating that function from the job will change the job itself. So an essential function is inimical to the performance of that job. Most often I use the example of a custodian. All custodians may empty a trash can, some may mop, some may clean. If you remove vacuuming, if you remove trash removal from the job, it changes the duties of the custodian. Trash removal is ordinarily an essential function of a janitorial or custodial position. Employers need to review their job descriptions in planning for the challenges that come presented by the vaccine so that when we evaluate accommodation, we are sure of what is required of the employee, what must be done in-house by the employee, another overlay that's been added by the state and federal restrictions regarding remote work versus in-office or on-site work, and what are the marginal functions. A review of the job description to make sure that the essential and marginal functions are exactly in line with the requirements of the position and the legitimate business needs of the employer is critical. This is necessary because the equal opportunity and the governing courts that will hear the discrimination cases will scrutinize the employer's job description. They will look to see the assessment of the functions are essential, whether the position exists to perform that function, the experience of the employee who actually holds that position, the time spent performing the function, the consequence of not performing the function. If these elements do not exist, our defense that we could not accommodate the position will be compromised. When I routinely review job descriptions for employers on a case-by-case basis, I often find that the job they believe is outlined in the job description, the job that the employee is actually performing, and the job that they require by virtue of accommodation are three very distinct jobs. The fact that it is not documented creates a problem for employers. It is critical that they review the essential functions versus the marginal functions and ensure that the requirements of the position are properly outlined as the foundation of the accommodation and interactive process. Similarly, remote work has come to the forefront for many employers through the pandemic and now the vaccination process. A remote employee is someone who is employed by a company but works outside of the traditional office environment. Again, I understand that many in our audience today have remained gainfully employed. Maybe few of their employees have actually worked remotely or from home during the pandemic process. Remote work is another potential viable alternative where there is an exception and refusal to undergo the vaccination process. If an employee needs to be removed from the workforce because with or without accommodation, they present a direct threat, remote work is a possible alternative. Employers will have to justify why the employee cannot perform their work duties either remotely or from home. That may be obvious in certain situations, particularly in the construction or manufacturing environment, but for senior management, executive offices, and some businesses, remote work is possible and must be considered. Chelsea, any final questions?
Yes, our last question that I'm going to take today, Caitlin, how will the new administration impact this guidance, if at all?
Chelsea, that's a very expounded question. Unfortunately, this is unknown territory. The new administration, we're not even throughout the 100 days right now, and we have to see how it all pans out. Already we're seeing new developments with the mask requirements in public. The new president had already promised 100 million doses of the vaccination in the first 100 days in office. Some sources say that he's on track, others say that he is not. We really just have to wait and see how this pans out. And as Jim addressed earlier, within the next few weeks, I'm sure there's going to be even further developments and guidance, and we will reconvene at that point and administer any new information that we can.
Thank you, Caitlin. Folks, that concludes our presentation today. I hope you enjoyed our efforts and found the information informative. As Caitlin suggested, we do anticipate a second round of presentation to provide you with updated information. I encourage you to submit your questions online and or reach out to Caitlin and I at the email addresses listed on the screen. At this point, again, I want to thank both you for your patience, as well as Eric, Chelsea, and NEPIRC for the opportunity and partnership. And I want to turn the presentation back over to Eric for his final thoughts and conclusions.
Thank you very much, Attorneys Devine and Donahue, for sharing your expertise with us today in a very informative and engaging presentation. I'm confident that each of our attendees, as well as those that will view a subsequent rebroadcast of this event, will benefit greatly from the experience. I also thank Chelsea Coslett, our marketing specialist, as well as Randy Yash, our IT specialist, the entire team here at the Northeast PA Industrial Resource Center, and my colleagues across the state for all the dedication and effort that went into making this program a huge success that reached over 400 companies, not only within Pennsylvania, but across the nation. As mentioned at the beginning of the event, if you did not have your questions answered, please rest assured that Cipriani and Werner have agreed, as Attorney Devine indicated, to answer each of those questions. We'll compile those answers. We will post them up to our website, and all attendees will receive a link to that. Just give us 2 to 3 weeks to put that together. You'll also receive a link to the recorded version of this as well. If you have a very specific question, one of the questions that Chelsea did inform me of is, well, they have a specific question that they would like to be handled more confidentially. As Mr. Devine indicated, you are welcome to contact himself as well as his colleague, Attorney Donahue, for a more confidential one-on-one type answer, as opposed to having it on the main document. So please know you have that resource as well. The Pennsylvania Industrial Resource Centers appreciate the engagement of the manufacturers that took time out of their day today to join us in this effort, and our overall efforts to help our manufacturers recover more quickly and more comprehensively from the impacts of the COVID-19 pandemic. We stand at the ready to continue to help. I encourage each of our manufacturers to please reach out to your regional industrial resource center using the contact individuals and their emails here shown on the last slide. Put you directly in touch with the president and CEO or other management team member at that IRC for immediate response to your inquiries. For more information on upcoming IRC network events, or just to remain current on news of importance to our regional manufacturing and statewide manufacturing community, please join us on social media by searching NEPIRC, NEPIRC on any of the platforms below, LinkedIn, Facebook, or YouTube. Thank you again for your time. We wish you all a very safe and productive remainder of your day.